Back in 1991, President Bush gave a speech to Congress wherein he used the phrase New World Order, which thereafter caused concern to large numbers of Americans. What did President Bush mean by this phrase? Was he indicating that sometime in the future a worldwide government would be created? What kind of government would a worldwide global government be? Would it be peaceful? Or would it be tyrannical? Many were disturbed at the suggestions and prospects for a New World Order. The United States has been a member of the United Nations since its founding. In fact, Rockefeller donated the land where the UN's headquarters now sits. Since then, the UN has appeared to function in some ways like a world government, sometimes doing things that appeared good, and at other times acting in unfavorable ways. If a world government is to be created, either through the UN or by some other method, how would the United States be brought into it, whether sharing power with that government or by being subservient to it? I suggest that such a route would be through the treaty powers of Congress, which many know little about. In 1787, the Philadelphia Convention proposed a new U.S. Constitution, which was ratified in 1788. Article 1, Section 8 of the Constitution granted to Congress 17 very specific powers, and the Ninth and Tenth Amendments reserved all remaining powers to either the states or to the people. But the power to negotiate treaties was granted solely to the President, and treaties needed only to be ratified by the U.S. Senate. The U.S. House played no role in either the negotiation or ratification of treaties. Now let's examine the provisions of Article 1, Section 8 of the United States Constitution. You now have on the screen the various provisions of Article 1, Section 8. They're divided into clauses. Now, a new government was being created by the United States Constitution. And of course, a government needs a power of tax. So obviously, the first clause in Article 1, Section 8 deals with the power to lay and collect taxes, duties, imposts, and excises. The power to tax was granted to Congress. Clause 2 provides that the new Congress, on behalf of the government of the United States, may borrow money on the credit of the United States. Clause 3 authorized Congress to regulate interstate and foreign commerce. Clause 4 established uniform rules for naturalization and uniform laws on bankruptcies. Clause 5 authorized Congress to coin money and regulate the value thereof. Now, Clause 6 is real important. Let me stop right here and provide some background information. There are 4 crimes mentioned in the United States Constitution. One crime is treason. However, authority regarding treason isn't in Article 1, Section 8 of the Constitution. It's in other provisions of the Constitution. But one of the crimes Congress is authorized to make penal appears in Clause 6, highlighted in yellow. Congress is authorized to provide for the punishment and counterfeiting of the securities and current coin of the United States. Now let's move down the page. Let's skip over 8, 7, 8, 9. Let's go down to 10. Clause 10 of Article 1, Section 8 set forth 2 other crimes that Congress is authorized to make penal. Clause 10 says that Congress can define and punish piracies and felonies on the high seas and offenses against the laws of nations. Now let's move on through. You can see there are other clauses in the Constitution, but let's move on down to Article 2. Article 2 established the office of the President of the United States, gave him certain powers and duties and responsibilities. And in Section 2 of Article 2, he was granted the power to negotiate treaties. Section 2 says he shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. Now, the purpose of this 2-part video series is to educate other Americans about the treaty powers of Congress, the treaty powers of the President of the United States. It's real important to know, once you understand these powers, how they operate in very specific instances. Just seeing how they operate is extremely educational. It is very important. One of the examples that is used by a lot of people that, talk about treaties is the examples shown by the bird treaty cases. There's an important lesson that can be learned just simply by reviewing some old cases as well as some old lawful authority, acts of Congress, and treaties. And that's the purpose of the first part of this video. Now, in 1913, Congress came along in an Appropriations Act, provided for the authority of the Department of Agriculture to regulate the hunting of migratory birds. Now, up on the screen, you will see in yellow the highlighted part of this Appropriations Act. It says all wild geese, wild swans, brant, wild ducks, snipe, plover, woodcock, rail, wild pigeons, blah, 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 shall hereafter be deemed to be within the custody and protection of the government of the United States, and shall not be destroyed or taken contrary to regulations hereinafter provided. Now, this act went further and said the Department of Agriculture shall issue regulations that hunters must follow if they're going to be hunting migratory birds. Now, with this authority in this 1913 Act, the Department of Agriculture did, in fact, issue some regulations. Now, that happened in 1913, and the legal history of this issue shows that this act regarding the hunting of migratory birds was being enforced. Sometime before May 25th of 1914, the United States had brought charges against a hunter in Arkansas by the name of Shaver. Quite obviously, sometime in early 1914, some Department of Agriculture game wardens had been out in the woods in Arkansas and had seen Shaver hunting wild birds. He apparently shot some. Now, he gets drugged before the court of Judge Treber. I'll show you that in a minute. This is a real important case because it demonstrates what happens when there is no treaty in play regarding a federal regulatory scheme, and what can very well happen once you have a treaty involved. Now, Shaver for Judge Treber, he has these charges pending against him, and he makes a motion to dismiss because the act in question is unconstitutional. Now, we're not going to deal with the separate subject matter of whether or not an Appropriations Act can be lawful authority. Here, we're not going to touch that subject. The only thing we're going to do here is to note that there was a law passed by Congress authorizing the Department of Agriculture to control the hunting of wild birds under the theory that the wild birds were property of the United States. Now, after Shaver made this motion to dismiss because the statute was unconstitutional, Judge Treber studied it and ultimately rendered a decision. Now, what you'll find on the screen as we go through this video are a number of cases, and we're going to be reading from what are called headnotes. Now, law publishers like West Publishing Company, when they publish an opinion from a court, a single district court judge or an appellate court, Supreme Court, they read the opinions and they break down into little headnotes, the important parts of the opinion that they're publishing. We call these headnotes. And headnotes are real good summaries of the major provisions, the major points that a judge makes in a particular case. Now, here you have in headnote number 5 that I've got in yellow that's the screen. This is one of the decisions that Judge Treber made in this case in response to Shaver's motion to dismiss because the statute was unconstitutional. Let me read. Migratory birds are not, when on their usual migration, the property of the United States within the meaning of the Constitution, empowering Congress to adopt rules respecting the territory or other property of the United States. But they are the property of the states in their sovereign capacity as the representatives of the people. Protecting migratory birds cannot be sustained. This act cannot be sustained as an exercise by Congress of the right to adopt regulations for its property. The reason being, the law at that time was migratory animals, birds, other mammals, inside of a state are really the property of the state itself and not the federal government. Judge Schreiber went on and said, the act of March the 4th of 1913 protecting migratory birds and game is invalid because not authorized expressly or by necessary implication by the Constitution. And there you on the screen you can see the name of this judge. This is real important for you to remember the name of this judge, Judge Schreiber. Now I'm going to scroll through various provisions of this opinion, as you can see on the screen right now. He reached his conclusion. It is equally well settled that as to all internal affairs, the states retain their police power, which they, as sovereign nations, possessed prior to the adoption of the national constitution, and no such powers were granted to the nation. The court is unable to find any provision in the Constitution authorizing Congress, either expressly or by necessary implication, to protect and regulate the shooting of migratory wild game when in a state, and is therefore forced to the conclusion that the act is unconstitutional. Now that's one case during this period. There is a second case that is also real important in this little demonstration of what happened regarding the migratory bird laws of the United States. A year later, the Department of Agriculture sent its agents out into Kansas. Some game wardens went out into Kansas. And this time they caught 3 guys hunting and killing migratory birds. On the screen, you can see the name of one of them, McCullough. You can see another name, Savage. And there's that third name, Sapp. So these 3 guys are being brought into federal court, charged with the crime of hunting and killing migratory birds. Now, this is a different judge. Here you can see the head notes. And the head notes are real good summaries of what the decision is about. I'm going to read the head notes. That an act of Congress not authorized by the powers delegated to Congress by the federal Constitution, it may have a laudable purpose. That exigencies of the case are great, or that the powers of the state are impudent. Like the states are impotent to do something about the problem. That argument will not sustain a federal act. The Act of 1913, providing that migratory birds shall be deemed within the custody and protection of the government of the United States, and shall not be destroyed or taken contrary to regulations which the Department of Agriculture is thereby authorized and directed to adopt, is not authorized by the Commerce Clause of the Federal Constitution, as the title to wild animals and birds is in the state. Let's move on down. On the last page of this opinion, the court makes its observation and conclusion. The several states, has been seen, possess the most absolute and plenary power of control over the subject matter of wild animal and wild bird life within their territorial domains. In fact, it's impossible to conceive or grant any other conclusion. And so in this case, this judge in Kansas held, like Judge Schreiber, that this law appearing in an Appropriations Act of Congress was unconstitutional. So what does Congress do when, it's having its own court sit there and say, hey, this law is unconstitutional? Well, what Congress did is they went out and they ratified a treaty with Canada, Great Britain on behalf of Canada, to protect migratory birds. And how do you protect migratory birds? You regulate the hunting season. So in 1916, the president approached Canada, the president approached Great Britain, I guess, whichever one happened, and swung a deal with those authorities to protect migratory birds. Now, this is an objective. Here you can see on this first page of this treaty with Canada, one of the objections was clearly expressed. They wanted to protect migratory birds in the United States and Canada. The signatory parties noted many species of birds in the course of their annual migration traverse certain parts of the United States and the Dominion of Canada. These parties were desirous of saving from indiscriminate slaughter and of ensuring the preservation of such migratory birds as are either useful to man or they are harmless. So how do you carry out these objectives? How do you implement them? Well, as I said a minute ago, you regulate and control the hunting season. So here in Article 2, that's exactly what is agreed by the parties. The high contracting powers agree that as an effective means of preserving migratory birds, there shall be established the following close seasons, during which no hunting shall be done except for scientific or propagating purposes under permits issued by proper authorities. Article 6. Here is where the parties agree that they shall enact laws to protect birds and make sure that they're only hunted during the open season and they're not hunted during the close season. And this is one of the reasons. The high contracting powers agree that the shipment or export of migratory birds or their eggs from any state or province during the continuance of the close season in such state or province shall be prohibited except for scientific or propagating purposes. And the international traffic in any birds or eggs at such time captured, killed, taken, or shipped at any time contrary to the laws of the state or province in which the same were captured, killed, taken, or shipped shall likewise be prohibited. This treaty, was signed in August of 1916. As we saw a moment ago, it was ratified in December of 1916. Now, a year and a half later, in July of 1918, Congress gets around to addressing and implementing the Migratory Bird Treaty. It came out with the Migratory Bird Treaty Act. Section 2 provided that it shall be unlawful to hunt, take, capture, kill, attempt to take, capture, or kill, possess, offer for sale, sell, offer to purchase, purchase, deliver for shipment, ship, cause to be shipped, delivered for transportation, transport or cause to be transported, carry or cause to be carried by any means whatsoever, receive for shipment, transportation or carriage, or export at any time or in any manner, any migratory bird included within the terms of the convention between the United States and Great Britain for the protection of migratory birds. Now, the Secretary of Agriculture is authorized and directed from time to time to, regulate and control the hunting, taking, capture, killing, possession, sale, purchase, shipment, transportation, carriage, or export of any such bird. So they're establishing open and closed seasons by means of this federal law. And of course, regulations could be implemented by the Department of Agriculture to, more refine the implementation about how this actually be implemented. So what happened? Remember I mentioned Judge Trieber a minute ago? Now on the screen, can you see that same name? Trieber, district judge. He's confronting the issue in this cause is whether the act is constitutional. This, of course, involves the power to make the treaty. So here in this case, United States versus Thompson, this decision was rendered in June of 1919, probably January, February, March. Thompson had been bagged by some Department of Agriculture game wardens for hunting, shooting, and killing migratory birds in Arkansas. Now, what happened here? This judge Treber had 4 or 5 years before issued a decision in the Shaver case. Anybody could go look it up. There's probably local lore around Arkansas. This judge had found the migratory bird laws unconstitutional. So this defendant comes along and Thompson says, well, I'm going to make the same motion. It's a pure, sure winner. Well, this time the government obviously comes back and says, well, you did make that decision 4 or 5 years ago, but things have changed. We have now gotten the treaty with Canada, and we got federal implementing laws implementing that treaty. This causes Judge Treber to do an about face. Let's review some of the parts of this decision of Judge Treber. On the screen, you can see the power to make treaties has been frequently before the Supreme Court, and there is not a single instance in which a treaty has been declared unconstitutional, although many of them affect rights exclusively under the control of the states, and if enacted as statutes by Congress, would have been held void. Judge Treber went on to quote some United States Supreme Court decisions regarding treaties. On the screen, you can see that the treaty-making power has been surrendered by the states and given to the United States is unquestionable. It is true also that treaties made by the United States and in force are part of the supreme law of the land, and that they are binding within the territorial limits of the states as they are elsewhere throughout the dominion of the United States. The treaty-making power vested in our government extends to all proper subjects of negotiation with foreign governments. To subject the treaty power to all the limitations of Congress in enacting the laws for the regulation of internal affairs would in effect prevent the exercise of many of the most important governmental functions of this nation in its intercourse and relations with foreign nations, and for the protection of our citizens in foreign countries. The states of the Union may enact all laws necessary for their local affairs, not prohibited by the national or their own constitution, but they are expressly prohibited from entering into treaties, alliances, or confederations with other nations. If, therefore, the national government is also prohibited from exercising the treaty power, affecting matters which for internal purposes belong exclusively to the states, how can a citizen be protected in matters of that nature when they arise in foreign countries? Judge Treber ends his decision with this. In the opinion of the court, the power to make the treaty in question exists, and the act of Congress to carry it into effect was in discharge of a moral obligation assumed by the nation by the convention with Great Britain. So the motion to dismiss of Thompson was denied. Now there's another second interesting case later on, United States against Rockefeller. Well, this guy by the name of Rockefeller was in Montana in a boat and shooting wild ducks. And he did that right in front of some Department of Agriculture game wardens. Wow, how silly of him. He made the same motion. This law is unconstitutional, the law that I'm charged with violating. And, you can sit down and you can read this decision, but I'll simply note this section of it. Treaties in relation to such subjects and within such limits by the federal Constitution are made the supreme law of the land, to which all state constitutions, statutes, and rights yield to the extent of any conflict. And so this judge in Montana said this: it is believed the treaty and the statute and regulations effectuating it are valid exercise of federal power, and so are constitutional. Now, let me kind of close the loop here. Another case that came from Missouri, shortly after this, went all the way to the United States Supreme Court. That case is called Missouri versus Holland. We'll be talking about it later on during the course of this video. In Missouri versus Holland, the Supreme Court came out and it addressed the treaty with Canada regarding the protection of migratory birds, as well as the federal law implementing it. And the Supreme Court in Missouri versus Holland held that this was perfectly constitutional. Now let's just not stop there. We've seen thus far that an act of Congress can invade the jurisdiction of the states, and a court will find that law unconstitutional. However, if you get a treaty with another country, implement it by federal law, and start enforcing that law, the court's going to say that's perfectly constitutional, even though there's no express power found in Article 1, Section 8 of the United States Constitution, those 17 powers. A treaty, which there's no limit to the subject of treaties, a treaty can give authority to Congress. A treaty can give authority to federal officials, federales, to do something that would otherwise be unconstitutional. Now let's quickly go through the Cochran versus United States. Now this is a case where, they're still out enforcing the law. This happens in the Seventh Circuit, obviously in Illinois. But these defendants were bagged for baiting migratory birds. They were probably a part of a game club. They were out on a lake, and they attracted the migratory birds to land in the water so that you could be shot, either flying in or flying away. And the reason why the birds would be landing on the lake was because they were being fed corn and rye to attract the wild ducks, migratory game birds that were included in the terms of the convention between the United States and Great Britain. Well, to make a long story short, these regulations regarding doing things like baiting birds, these regulations were found to be perfectly constitutional. They were pursuant to both the treaty as well as the federal law. And in this decision, the Court of Appeals for the Seventh Circuit in this Cochran case, recounts the history thus far that we've already covered. But I want you to see it in print and an opinion. Prior to the enactment of the treaty above referred to, there was doubt and uncertainty as to the power of Congress to deal with the hunting and killing of migratory birds. And guess what? The court cites to the cases that we've just mentioned, the Shaver case and the McCulloch case. These two decisions denied to Congress the power to so legislate. Subsequently, the Supreme Court definitely settled all questions as to the validity of the treaty and the first act of Congress enacted pursuant to the treaty. Both were held constitutional. Here's the conclusion of the court in the Cochran case. Our conclusion, therefore, is that the legislation was authorized by the Commerce Clause of the treaty. Let's review two more cases. Here on the screen, you'll find a decision of the Ninth Circuit, a case styled the Alaska Fish and Wildlife Federation and Outdoor Council Incorporated. They had sued Frank Duckel, the director of the U.S. Fish and Wildlife Service. How did this case come about? Well, a bunch of natives, Alaskan natives, the Alaska Fish and Wildlife folks, and swung an agreement with them to allow them to hunt out of season during the closed season. In fact, they were authorized to engage in subsistence hunting and fishing. You'll see the names of these agreements later on. Well, the Alaska Fish and Wildlife Federation sued the director of the U.S. Fish and Wildlife Service. And then the Alaska Natives intervened in this litigation in the district court. Well, so the issue before the district court in this case was this, are these agreements, state agreements, valid when they appear to be contrary to the terms of the treaty, especially since they allow the Alaska Natives to engage in subsistence hunting and fishing year-round, even during the closed season. So that's the issue in this case. The ultimate conclusion of the Ninth Circuit is that, well, hey, the treaty and treaty implementing laws regarding hunting and fishing of migratory birds, wild animals, it's got to agree with the treaties in question. A state agreement that opens up for hunting year-round migratory birds and other animals, the Ninth Circuit said that's illegal, in conformity with the with the treaty in question. Now, here are the names on the screens of the agreements that the Alaska Fish and Wildlife Service officials had made the Alaska Natives. It was the Hooper Bay Agreement and the 1985 Goose Management Plan. Now, what I'm planning to do is to go through this treaty and just read some of the highlighted parts so that you can understand, here's an appellate court saying this is the way treaty law operates. The Migratory Bird Treaty Act grants the Secretary of discretion to regulate the taking of migratory birds, but that discretion is limited to actions in accordance with the treaties the Migratory Bird Treaty Act implements. Now, the court goes to tell us a little bit about the history of the law in this field. The Migratory Bird Treaty Act was enacted in 1918 to implement the convention between the United States and Great Britain birds. See those references. The MBTA has since been amended to implement the conventions which the United States has signed with Mexico, Japan, and the Soviet Union. See those references. The Migratory Bird Treaty Act was amended in 1978 by the Fish and Wildlife Improvement Act to implement the United States USSR Convention. And here's the conclusion of the court. We hold that the Migratory Bird Treaty governs the subsistence hunting of migratory birds in Alaska. The MBTA was not superseded by the 1920 law that was in question, authorizing these agreements. As enforced today, the MBTA permits the Secretary of the Interior to adopt regulations permitting subsistence hunting of migratory game birds. These regulations may not, however, contravene the treaties with Canada, Japan, Mexico, or the Soviet Union. To the extent that the Hooper Bay Agreement and the 1985 Goose Management Plan conflict with the United States against Connors, 10th Circuit case. This guy was apparently a member of the Colorado Retriever Club. And the Retriever Club was engaged in hunting, probably on a Saturday or some day of the week, and some birds were shot. And this was observed by some federal gaming officials. And so they brought charges against this guy, Connor, probably several others. Connor asserts a defense based on the facts. He says that his hunting club had raised the birds that they were shooting. And so the issue in this appeal dealt with, what birds are subject to these migratory bird treaties? Must they all be wild birds? Does the treaty cover not only wild birds, but does it also cover captive raised birds? That was the issue in this case, and here again the court notes, you can see it on the screen, the history of this field of federal law regarding the hunting of migratory birds. In 1916, the United States of America and the United Kingdom of Great Britain and Ireland entered into a convention for the protection of migratory birds in the United States and Canada. See the convention. The Migratory Bird Treaty Act was enacted to give effect to that treaty in July of 1918. The constitutionality of the treaty and the act was subsequently tested and upheld in Missouri versus Holland. In 1936, the United States of America and the United Mexican States entered into a similar agreement for the protection of migratory birds and game mammals. Later, in March of 1972, the United States and the government of Japan entered into a similar convention, which was thereafter incorporated into the provisions of the act. The agency charged with the enforcement of the subject treaties pursuant to the provisions of the Migratory Bird Treaty Act is the U.S. Fish and Wildlife Service. Oh, so some federal agencies are really treaty-based. Inasmuch as the two treaties and the controlling regulations specifically refer to wild ducks, and the criminal statutes must be strictly construed, with ambiguities resolved in favor of the accused, we hold that the provisions of the Migratory Bird Treaty Act do not apply to the killing or attempted killing of captive reared ducks. Now, the purpose of this video is to explain to our listeners how treaties have operated in the field that a field of law that a lot of people wouldn't think would be necessarily of federal constitutional authority. But we've seen thus far that, with a treaty, what would otherwise be prohibited and unconstitutional for the federal government to do, now it can be done with a treaty.